Hi, my name is Joan Grimes, and this is my daughter, Jennifer Wallace, and we are estate planning attorneys in Walnut Creek, California. And we are very happy to be here today to talk about blended families. But before we get going, just to remind you this little disclaimer, we are only practicing in California. So this may or may not apply where you are if you're in another state or another country.
Other country, we definitely can't.
No, we cannot. We cannot do that. And you really should, if you have these kinds of issues, you really should seek legal counsel. This is good basic information, good generalized information, but for your specific situation, you should seek legal counsel. So with that being said, blended families are...
What is a blended family?
A blended family is when two people come together and they typically each have children from a prior relationship.
Yeah, second marriages.
Second marriages,
we call them blended families.
And people come in all the time, and you can almost tell who the blended family is before they even sit down because they're
a little anxious.
They're a little anxious, and they want so much to do right by the other person.
Yep. And by their kids.
And by their kids, and they're trying to keep harmony in the family.
With everyone. They're trying to keep harmony with the children, with the new spouse, and their kids have looked at them saying, don't mess this up.
Right, absolutely.
Don't mess this up.
Right. This is if this money is intended for us. These assets are intended for us.
Don't create World War III in our family.
Right.
Don't mess this up. So there's a lot of pressure.
There's a lot of anxiety.
To get it right. And we tend to spend a lot of time with blended families thinking through lots of options. But the good news is for blended families, they have lots of options.
There's lots of options.
There's lots of ways.
And it doesn't have to be super hard.
I mean, other people have done this before.
Right.
So you don't have to reinvent the wheel. Just choose the approach that works for you. Take it and adopt it, modify and tweak it.
And go.
Right.
And then you're going to be fine. I mean, that's really one of the reasons we wanted to do this is people come in and they're super anxious and we want to
give them
options and make people feel better about having a blended family, and so they also do their estate planning, which we really need you to do.
Please don't avoid it.
Don't avoid it. Okay, so let's talk about the basic.
There's two basic approaches.
Yes.
To blended families. I think you have lots of other options, but there's two basic options, especially with blended families. I always start with, you have two options. The first option is you and your spouse. I'm going to use Tom and Joan. You are Joan. Your husband is Tom. Let's pretend you have a blended family.
Okay.
And don't have a blended family and been married forever, but let's pretend like you do.
Okay.
You're just use an easy example to use. So you and Tom have two options. You can either put all of your stuff into one box, or you can have kind of maybe three boxes.
I could have my own box.
Tom could have his own box, and then they could have a joint box. Mm-hmm. So those are the two big options.
One trust.
One common trust for everything. Or maybe three trusts.
Where I have my own.
Joan has her own trust.
Tom
has his own trust. And then they have a common trust together. We're going to walk through both of them.
So it sounds to me like it would be much easier for us to have three trusts, except for the lawyer who's going to make more money because he has three trusts, than to have one trust. So why do people end up with just...
I think a lot of our clients say, well, we just want one trust. So which one?
Right.
And I almost think three trusts is easier than one. Let's walk through them.
Yeah.
Actually, let's start with the three trusts first, just because it's a little bit easier to explain.
Okay.
So if we have a blended family, we're creating three trusts. Joan will have a separate property trust. Tom will have a separate property trust. And then they can have a community property trust if they want. Optional.
So okay. If they end up, so let's give this example.
And a lot of families actually, this is already easy because if you already had a trust before you married Tom.
Right.
With all your assets into it, that could be your separate property trust. Tom, maybe he had already had a trust before he got married to you, and he has all of his assets in there.
And then we come to us
together
saying, well, now we want to buy a house together. We've been together now, 10 years, and we've been living in, my house, or we've been living in his house, but we really want to have a house together. So they say, we really want to have this. And that's the easy one, is where what you just put in here in this
community property
is community property, but which what we mean is it's from earnings that the community made. Okay, so it's our wages, our earnings, what we have together, what we've done together.
Good point. Let's flesh that a little bit. Separate property in California as a general rule is things that you came to the marriage with and that you earned or inherited before you got married. And then community property is assets that you acquire together as a married couple, with the exception of gifts and inheritance are always separate property because they are never earned. They're always separate property unless you gift them to your spouse. So anything that Joan earned before she got married, money she earned, houses she bought, things that she received is her separate property. And then things that Tom earned or received before the marriage, his separate property. Anything that you guys earn together or make together or buy together is community property unless you agree to it in another way. But what's super important in all of these trusts, regardless of what approach you do, is postnuptial agreements or prenuptial agreements to lay out what are the rules and what assets belong. What assets did you come to the marriage with? What assets did Tom come to the marriage with? Or maybe what assets have we already acquired together?
Right. So just everyone is clear about the rules.
Okay, so let's go through these 3 separate trusts that we have. Okay. So if we had 3 separate trusts, you have your own trust, Tom has his own trust, and you have a community trust together. I personally love that because then when you die first, if there's enough money, you could just leave your stuff in your trust to your children. Boom.
Right.
Your children that's an option. And Tom can do the same thing. If he dies first, his children could, boom, get his assets. And then you guys could create rules together with regards to the assets in your joint trust.
So that works. That scenario works really, really well.
For very wealthy people.
Right. So if you have lots of money. And
do 3 trusts.
Do 3 trusts. Because then I can live on my own like I did before I met Tom. Mm-hmm. And I have enough money so I don't need to rely on Tom's money.
If Tom died first, Tom dies, children can just get it.
They can just get it.
And children love this plan because when their parent dies, they get their parents' inheritance.
Right. So
they get their money. They get their parents' money ASAP. They love it.
Right. So if you have lots of money, this plan is a very good plan for you.
Yeah. So let's recap. You've died first, and when you die, your children can get. Maybe they don't even need to get all of your assets. Maybe your trust, your separate trust. Your box says that upon your death, maybe half of the assets in your box go to your children and half maybe go to your spouse.
Right. So that's a little variation on the theme. To make sure that Tom is okay, I leave him.
Maybe Joan came to the marriage and she was very wealthy and Tom wasn't as wealthy. Right. And
that really would not be the example. Just anyone who knows me is that Tom is a super thrifty person here. So Tom would have been the one.
We're just using examples.
But no one would believe that.
Well, okay. Well, just the example.
Okay, the example.
That you have come to the marriage with a lot of money and Tom has not come to the marriage with a lot of money. And they still have 3 trusts. Tom has a separate trust, you have your separate trust, and then we have a community trust. But maybe you're a little worried that upon your death, if you just left everything to your children, Tom might not be okay. So your trust could say lots of things, but your trust could say that upon your death, maybe half of your wealth goes to your children and half of it or a certain percentage goes to Tom. Alternatively, you could even do that all of your stuff stays in the box for the rest of Tom's life and Tom gets to take maybe the income
from these assets. That's a very common provision. That's a very common provision.
Gets to take the income off of the box for the rest of his life. And then upon Tom's death, the money goes to the children. You could also create separate rules for your box of who's in charge. Maybe Tom isn't in charge of your box. Maybe it's one of your children who manages and acts as the trustee. There's lots of ways to do it. It's so exciting. You can do anything you want.
But if you have plenty of money, okay, that is what typically people will do, is they will have 3 trusts. That's the typical scenario.
Each spouse has their own separate property trust and then a community property trust together.
However, if you don't have lots of money, okay, but you have like most people, I would say 80% of the people who come in here.
So let's go through this situation. This is a situation in which we have a blended family, but
a lot of times minor children. So they're
blended family. And the real issue is that if one spouse were to die, the other spouse might not be okay. It might not have enough money.
Literally may not have enough money
to continue on.
Right.
And so
they have to join forces. They have to join forces, and they have to put all their assets into one box to make sure each other is okay.
And that is completely fine.
Absolutely.
That is completely fine. And so, but this one box needs to really have beefed up rules. We got to have the rules outlining what's going on. The first big thing that has to be very clearly identified in this trust is, do we have a prenuptial or postnuptial agreement? And who came to the marriage with what? So if Tom is putting assets into the box, he needs to label, I put this in the box. This was mine before we got married. So just in case if you got divorced again, it's easy to pull those assets back and say, no, that was mine. I came to this marriage with that. Give that back to me. Additionally, you would say the same thing. I'm putting these assets into the trust, clearly identified, these are mine.
Most estate planning attorneys do not transmute assets. So if it was mine and I put it into the trust, it's going to go from Joan Grimes into the Grimes Brown trust, okay, whatever it is. And so they're not going to change it into like community property. It's going to still retain, it's going to be my separate property. It's just going to go into this box.
Yeah. Then let's say if you passed away first, so right. We're going to kill you off first. Sorry. In estate planning, we kill off lots of people as examples. It's terrible, but it's what we do. So in this example, Joan and Tom have put all of their joint assets together, but they've clearly identified who came with what, okay? Then if you die first, the instructions in this box could say that we're going to take this box and we're going to divide it in two. We're going to divide it into two. Joan's stuff that she had before the marriage and maybe one half of the community is going to go into this little sub box over here. And then Tom is going to have a little sub box as well. And the assets that he came to the marriage with will go over here. And maybe one half of the community property would go over here too. So we're dividing the box into two. Now, the rules for the box are very important because Tom could do whatever he wants with his box for the rest of his life. If he wanted to take all of the assets on this side and go to Vegas and blow all the money in one night, he could do it. He could do whatever he wants. Okay. He could also change the beneficiaries on this side of the box anytime he wants. He doesn't like his children anymore. Fine. He wants to leave it all to the next door neighbor. Fine. He can do whatever he wants. Joan's side, he's got to be careful with, very careful with. Her assets are over here and her rules are set in stone. And her rules may say, Tom, you can dip into my side of the box if you need to. And it might say you can dip into my side of the box for health reasons, education, maintenance, or support. That's kind of our common standard. So if you need the money, you can dip into it.
And sometimes people are very, very specific in that they'll say, you can only dip into this money over here if your money's gone. If your money is gone. Other times it will say, you can dip into this even if you have plenty of money over there.
You can do the rules however you want.
You can do the rules however you want.
But the nice thing about this, though, is you have locked your beneficiaries in place. So Tom cannot change the beneficiary. So your stuff Joan's stuff can go to her children no matter what, if there's anything left over.
If there's anything left at the end of the day. And sometimes people will simply say that, Tom can only have income from here.
Yeah, you can do the rules however you want.
You can do, and sometimes you literally can make the rules whatever you want them to be. But you see that the reason we're still keeping everything in this box is because both people need they're going to need this to be okay.
But this requires some organization. If Tom is going to be in charge of both sides of the box, he has to be very careful, very, very careful with your side and your assets. He has to file separate tax returns. We actually have to move the assets. We have to clearly identify what assets are going onto this side of the box and what assets are going to this side. For those of you that are a little bit more familiar with trusts, a lot of times this side of the box is called the survivor's trust. A lot of times this side of the box might be called the bypass trust. There's a lot of other names for them, but the concepts are pretty much the same. Sometimes there also might be a third trust. But we're working with the basics. So So yeah, that's.
But the reason people.
Was I missing anything?
No, that's perfect. No, I mean, the reason that people typically do this is because they need to do it. They need to. It's more It's really more complicated to make sure you get the rules right. And it makes it a little bit more complicated after the first person dies.
Oh yeah.
But people do it because they need it. Yeah. And ultimately that's why we want you to understand this, and we want you to figure out what is the best option for you.
And a lot of the children of blended families also like this approach as well, because they know that their step parent is okay. Well, the step parent can use Tom, for example, could use the money on Joan's side if he needed to, but there's rules in place, and they know that if there is anything left, that they will receive that amount. So it can also create some tension sometimes if Joan's children are suddenly watching Tom for the rest of his life of, are you using my mom's money? And do you really need that? So that can create tension at times. It is super important that no matter what approach you choose, if you have a blended family, that you are having lots of really good conversations with your children and your loved ones about what your wishes are, how this is structured, and what your plan is.
And that's a great point, because a lot of times people will do these trusts, but they will not talk enough in the trust itself about why they're doing it. And one of the things when you do really good estate planning is you say in the trust why you're doing things.
So what is your intention?
What is your intention? Don't let people just tell you it's boilerplate and this is what you're supposed to do. Good estate planning is not boilerplate. Good estate planning has a lot of work put into it to make sure.
Has a lot of because statements. I have done this because I am concerned about this.
These are my concerns. This is what I want to see happen.
This is why I've done this.
If it's possible, this is what I want done. And so if you don't see that in your estate planning, you really should look elsewhere.
Well, you can amend it to include statement of intentions.
Statements of intention are very, very important.
Really helpful.
They help everyone later on to understand why we were doing what we're doing.
Also, if you have a blended family, please do this planning early in the relationship, kind of figure out, and you can change, obviously, the structure at any time, but getting things organized. It is very hard to do this kind of planning with blended families if assets have already been really commingled.
Right.
If the waters have gotten really muddy.
Yes, it's much better to get this straight early on.
And create a system that works.
Create a system, and then it will help your own relationship, because you will know
with your spouse and with your children.
Right, because you'll know that you're taking care of your spouse
and your children. You're being responsible for both.
Right.
So, yeah, if you have any questions, you can check out our website. You can call our office. Again, we always offer free 30-minute consultations. But, create a plan. Blended families, they are tough, and they do require kind of a lot more than the average family, but there's lots of options out there.
There's great options, and, the more the merrier.
Families? Blended families?
Well, because you have more children, you have more things to do.
Oh, yeah. Okay. That's true.
I commend people for really, taking the chance, and, because it's not easy.
Love again.
Yes, it is.
We don't offer marriage advice.
No, we're not supposed to. We're not licensed. We're not licensed.
And on that note, if you have any questions,
give us a call.
Thanks.